Today, the Constitutional Court hands down judgment in an application brought by the Secretary for the Judicial Commission of Inquiry into allegations of state capture, corruption, and fraud in the public sector, including organs of state, being the applicant, for an order declaring former President Jacob Zuma, being the first respondent, to be in contempt of court for failing to comply with an order made by the Constitutional Court. In December 2020, in the matter of Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state versus Zuma, hereafter referred to as CCT 295/20, the applicant approached the Constitutional Court on an urgent basis for an order that would compel Mr. Zuma's cooperation with the Commission's investigations. On 28 January 2021, the Constitutional Court handed down judgment ordering Mr. Zuma to attend the Commission and give evidence before it. The judgment and order were served on Mr. Zuma, who responded by releasing a public statement in which he alleged that the Commission and the Constitutional Court were politicizing the law to his detriment. From 15 to 19 February 2021, Mr. Zuma did not attend the Commission as ordered. Accordingly, the chairperson of the Commission announced that it would launch contempt of court proceedings. On the same day, Mr. Zuma published another statement in which he leveled serious criticisms against the judiciary and confirmed that he would neither obey the Constitutional Court's order nor cooperate with the Commission in any respect. The applicant proceeded to approach the Constitutional Court for direct access on an urgent basis, submitting that a court that grants an order retains jurisdiction to ensure its compliance. The applicant submitted that considering Mr. Zuma's former and current political position in South Africa, his conduct constituted a particularly reprehensible affront on the integrity of the rule of law and the Constitution. Accordingly, that it was apposite for the Constitutional Court, as the guardian of the Constitution, to respond to Mr. Zuma's efforts to undermine the judicial process. On urgency, the applicant submitted that the matter warranted swift intervention on the basis that Mr. Zuma's conduct poses a grave threat to the administration of justice and the rule of law. Mr. Zuma is an influential political figure who wields significant power to inspire others to defy courts. The public and forceful nature of Mr. Zuma's defiance compounds the risk posed to the rule of law, and Mr. Zuma's contempt persists unabated. It was the applicant's case that Mr. Zuma is guilty of the crime of contempt of court. It submitted that there can be no doubt that Mr. Zuma had knowledge of the order in CCT 295/20. His non-compliance with the court order was undeniable because he failed to attend and give evidence before the Commission, and he failed to present any evidence to avoid the conclusion that his non-compliance was willful and mala fide. The applicant further submitted that in ostensibly defending his contempt, Mr. Zuma conducted a politically motivated smear campaign of the Constitutional Court, the Commission, and the judiciary. According to the applicant, his tactics, coupled with his unique position, should count as aggravating factors in the determination of an appropriate sanction. Ultimately, the applicant sought a punitive sanction in the form of an unsuspended order of imprisonment for a period of 2 years on the basis that only a punitive order is appropriate, given that this is a unique and extreme case of contempt of court for which there is no meaningful precedent. Mr. Zuma did not oppose this application, nor did he file any submissions. The Helen Suzman Foundation applied to be admitted as Amicus curiae. Its main submission was that an appropriate sanction must be capable of vindicating the dignity of the court, as well as compelling compliance with the impugned court order. it submitted that the appropriate sanction may be an order for Mr. Zuma's committal for a minimum compulsory period, coupled with either of the following: an order which would curtail further imprisonment where Mr. Zuma voluntarily testifies before the Commission, or an order directing the Sheriff of the High Court to escort him to the Commission to testify following a mandatory period of imprisonment. The Constitutional Court is satisfied that the Helen Suzman Foundation met the requirements to be admitted as Amicus Curiae. Its submissions are relevant and are of assistance, particularly to the question of sanction. It is therefore admitted. In this matter, 2 judgments have been penned. The majority penned by myself, with Matlanga J, Majid J, Mhlantla J, Pile A.J., Tlaletsi A.J., and Shikl J concurring, and a dissent penned by Theron J, with Jafta J concurring. I shall begin with the findings of the majority of the Constitutional Court. Let me begin by saying this. It is the lofty and lonely work of the judiciary, impervious to public commentary and political rhetoric, to uphold, protect, and apply the Constitution and the law at any and all cost. The corollary duty borne by all members of South African society, lawyers, lay people, and politicians alike, is to respect and abide by the law and court orders issued in terms of it, because unlike other arms of the state, courts rely solely on the trust and confidence of the people to carry out their constitutionally mandated function. The matter before us has arisen because these important duties have been called into question, and the strength of the judiciary is being tested. I penned and now hand down this judgment in response to the precarious position in which the Constitutional Court finds itself on account of a series of direct assaults as well as calculated and insidious efforts launched by Mr. Zuma to corrode its legitimacy. After all, it is the Constitution alone that we owe our allegiance. Accordingly, we are here because we have no choice but to respond as firmly as circumstances warrant when we find our ability to uphold it besieged. This matter engages the Constitutional Court's jurisdiction. These being contempt proceedings, the Court's power to protect its own processes in terms of Section 173 of the Constitution is implicated. Furthermore, when the constitutional safeguards of the judiciary are undermined so egregiously, as in this case, Section 173 empowers the Court to respond swiftly and effectively in its own interest and in the interest of justice. This matter also concerns the protection of the authority of the judiciary to carry out its constitutional functions vested in it by Section 165 of the Constitution, which functions are threatened by acts of contempt of court. Thus, the issues at the heart of this matter are irrefutably constitutional issues. On the question of direct access and agency, the Constitutional Court holds that this matter is so evidently extraordinary that a departure from ordinary procedures is warranted and is in the interest of justice. Never before has the authority and legitimacy of the Constitutional Court been subjected to the kinds of attacks that Mr. Zuma has elected to launch against it and its members. Never before has the judicial process been so threatened. It goes without saying that neither the public's vested interest nor the ends of justice would be served if we decline to exercise our special authority as the guardian of the Constitution, and if this matter were to be required to traverse the ordinary and lengthy appeals process. Furthermore, the vigor with which Mr. Zuma is peddling his disdain of the Constitutional Court and the judicial process carries the risk that he will inspire others to similarly defy court orders. It cannot be gainsaid that the longer that Mr. Zuma's recalcitrance is allowed to sit in the light and heat of the day, so the threat faced by the rule of law and the administration of justice curdles. Because of these exceptional circumstances, it is in the interest of justice to grant direct access and to do so on an urgent basis. The Constitutional Court holds that there can be no doubt that Mr. Zuma is in contempt of court. A judgment and order was handed down in favor of the applicant in CCT 295/20. Mr. Zuma was served with the order, and it is impossible to conclude anything other than that he was unequivocally aware of exactly what it required of him. Mr. Zuma failed to appear and give evidence before the Commission on the date so ordered, and similarly failed to file an affidavit in accordance with the chairperson's directive. Mr. Zuma is therefore in blatant violation of the court order made in CCT 295/20. To his peril, Mr. Zuma has not presented any evidence to establish a reasonable doubt as to whether his disobedience of the order was willful and mala fide, and the extent to which Mr. Zuma has attempted to justify his defiance through public statements is of no relevance. The statements were not formally pleaded, so fall to be disregarded. The Constitutional Court can do nothing but conclude that Mr. Zuma is guilty of the crime of contempt of court. The majority emphasizes that it cannot be gainsaid that orders of court bind all to whom they apply. This, in addition to typifying common sense, the Constitution itself enjoins in terms of Section 165, subsection 5. This is because the constitutional right of access to courts would be rendered meaningless unless orders are capable of being enforced by those in whose favor they are made. It is also noteworthy that contempt of court is not an issue between the parties, but is an issue between the court and the contemptuous party. Thus, although the harm caused through contempt of court to successful litigants like the applicant is by no means unimportant, the overall damage caused to society by conduct that poses the risk of rendering the judiciary ineffective and eventually powerless is at the very heart of why our law forbids this conduct. Suffice it to say that the mischief the Constitutional Court has been called upon to address is not that Mr. Zuma failed to comply with the summons and directive issued by the Commission, but rather that he failed to comply with the order of the Constitutional Court. Following from the finding that Mr. Zuma is in contempt of court, the crisp question with which the Constitutional Court is seized is the appropriate sanction. A sanction for contempt of court can take the form of suspended committal, otherwise known as a coercive sanction, or unsuspended committal, which is a punitive sanction. The purposes of each differ, made primarily to ensure the effectiveness of the original order. A coercive sanction gives the respondent the opportunity to avoid imprisonment by desisting from the offensive conduct and complying with the original order. A coercive order only incidentally vindicates the authority of the court that has been disobeyed. Conversely, in terms of a punitive order, a sentence of imprisonment cannot be avoided by any attempt to comply with the original order. The sentence is related both to the seriousness of the default and the contumacy of the respondent, and the order is influenced by the need to set an example and assert the authority of the court. Bearing this in mind, the majority holds that a coercive order which uses the threat of imprisonment to compliance would be both futile and inappropriate in these circumstances. Of course, society holds an interest in Mr. Zuma testifying before the Commission, given that it was under his presidency that the alleged corruption and malfeasance under the investigation by the Commission took place. Nevertheless, notwithstanding the importance of the work of the Commission, the Constitutional Court cannot be so naive as to hope for his compliance with the order made in CCT 295/20. Mr. Zuma has repeatedly reiterated that he would rather be imprisoned than cooperate with the Commission or comply with the order made in CCT 295/20. Accordingly, it defies logic to believe that a suspended sentence, which affords Mr. Zuma one final opportunity to submit to the authority of the Commission, would have any effect other than to prolong his defiance and to signal dangerously that impunity is to be enjoyed by those who defy court orders. An additional deficiency with a coercive order is that the punitive effect of it would only operate upon future non-compliance. In other words, it wields no punitive power in respect of Mr. Zuma's contemptuous conduct, already so worthy of rebuke. The majority finds that it is impossible to see how a coercive order could achieve any of the purposes of contempt proceedings. Neither the honor of the Constitutional Court nor the public interest in Mr. Zuma testifying before the Commission would be vindicated through a coercive order. In fact, the public has an equally important, if not more acute, interest in a functioning judiciary than in Mr. Zuma testifying before the Commission. Accordingly, the emphasis must be on ensuring that this society is one in which deference is shown to the rule of law, rather than in attempting to compel this most recalcitrant of individuals. If anything, a coercive order, likely only to be further defied, would plunge the integrity of the Constitutional Court into deeper waters. Anyone familiar with contempt jurisprudence knows that ordinarily proceedings result in coercive orders in terms of which compliance is suspended and calculated to compel compliance with the initial order. However, the case before us is so markedly distinct from any matter that has preceded it that it exceeds the expectation of legal precedent. This notwithstanding, an order of unsuspended committal certainly flows from legal precedent. To the extent that the minority judgment insinuates that the majority is creating precedent to punish Mr. Zuma alone, it is mistaken. The majority judgment does no more than apply the law cautiously to these new and unusual circumstances. Contemplating an order of unsuspended committal, the Constitutional Court was alive to the need to consider and indeed safeguard Mr. Zuma's constitutional right to freedom. Accordingly, directions were issued on 9 April 2021, in which Mr. Zuma was invited to file an affidavit on an appropriate sanction and sentence in the event he were found to be in contempt of court. The reason behind this was that the Constitutional Court was acutely aware that contempt proceedings are hybrid in nature because, although brought by civil process, they have a criminal component. After conviction in a conventional criminal trial, it is a violation of an accused person's right to a fair trial under Section 35 of the Constitution to impose a sentence without affording her or him an opportunity to say something in mitigation of sentence. However, this is not a conventional criminal trial, and the jurisprudence of the Supreme Court of Appeal and the Constitutional Court emphatically holds that a contemner in civil proceedings is not an accused person as contemplated by Section 35. Thus, unlike the minority, The majority judgment emphasizes that an accused person's rights, Section 35 rights, do not easily find application in civil contempt proceedings, and Mr. Zuma accordingly does not enjoy any of all of these rights. That being said, an accused contemner remains entitled to his or her rights in terms of Section 12 of the Constitution, which inter alia requires that no one be deprived of physical freedom unless a fair procedure has been followed. Therefore, although a contemner is not an accused person, the fair procedure required by Section 12 may, depending on the circumstances, necessitate a process akin to that afforded by Section 35. This is because taking away the liberty of an individual is a drastic step. By issuing the directions, the Constitutional Court afforded Mr. Zuma this unexceptional, commonplace entitlement to fair process dictated by Section 12 of the Constitution in a manner comparable to the Section 35 fair trial right. For pragmatic reasons, the main difference between the procedure followed in this matter and that which is ordinarily followed in a criminal trial is that, since contempt proceedings deal with guilt and sentence in one process, the invitation was sent out before a decision was reached on the question of guilt. In response to the directions, and instead of filing an affidavit as he was directed to do, Mr. Zuma addressed a 21-page letter to the Chief Justice. Unfortunately, but not entirely unexpectedly, Mr. Zuma once again squandered an opportunity to respect this country's legal processes, which guarantee all citizens fairness and equality before the law. Instead of furnishing the court with mitigating factors, he again aired his views through inflammatory statements intended to undermine the authority of the Constitutional Court and to portray himself as a victim. All of this, besides being scandalous, is totally irrelevant to the question of sanction upon which he was directed to make submissions. Of concern is that Mr. Zuma, along with his attorneys, has repeatedly attempted to justify his contempt by stating that by hearing this application while the outcome of his High Court application for the review of the decision by the chairperson of the commission not to recuse himself was outstanding, the Constitutional Court acted unconstitutionally. Of course, this is totally misconceived and calculated to confuse the public. If Mr. Zuma did not want to participate in the commission hearings whilst his review application was pending, he could have sought an interim stay of proceedings. Absent this interim relief, nothing could have precluded the Constitutional Court from entertaining the matter. The Constitutional Court went to great lengths to safeguard Mr. Zuma's rights. Consequently, there is simply no sound, no logical basis on which Mr. Zuma can claim to have been treated unfairly or victimized. His attempts to evoke public sympathy through unfounded allegations fly in the face of reason and are an insult to the constitutional dispensation for which so many women and men fought and lost their lives. Having found that Mr. Zuma, like all alleged contemners in civil contempt proceedings, cannot be described as an accused person as envisaged in Section 35, and confident that a fair procedure has been followed to safeguard the rights to which Mr. Zuma was entitled in these proceedings, the majority holds that no Section 36 limitations analysis arises in the circumstances. The majority finds itself faced with little choice but to send a resounding message that this kind of recalcitrance and defiance is unlawful and will be punished. After all, having no constituency, no purse, and no sword, the judiciary must rely on moral authority to fulfill its functions. On this basis, an unsuspended order of committal is the only appropriate sanction. Mindful of the novelty of this conclusion, I repeat that this case is exceptional. It is exceptional, not in the sense that Mr. Zuma is being treated exceptionally, but because there are certain exceptional features of this factual matrix that justify the imposition of an exceptional sanctions. These factors include, firstly, the nature and intensity of Mr. Zuma's attacks on the judiciary, and secondly, the relevance of his position as the former President of the Republic. It goes without saying that the importance of public confidence in the judiciary cannot be overstated. This is not to say that the judiciary is a unique branch of state that must be sheltered from the public and its criticisms. The Constitutional Court has itself accepted the benefit of robust and informed public debate about judicial affairs, and the judiciary is in no way exempt from the accountability it owes to the society that it serves. However, this does not mean that scurrilous and unfounded attacks on the judiciary and its members can be met with impunity. Protecting cause from slanderous public statements has little to do with protecting the feelings and reputation of judges, and everything to do with preserving their ability and power to perform their constitutional duties. His statements disclose no cogent, genuine, or factually supported critiques of the Constitutional Court or any of the other institutions and individuals whose integrity he so casually denounces. His statements do not fall into the category of criticisms accepted as tolerable in our constitutional dispensation. Not only are his statements intolerable, but the majority considers itself enjoined to take them into account when considering what sanction would be appropriate. This is because contempt is not the act of non-compliance with a court order alone, but encompasses the nature of that contempt, the extent of it, and the surrounding circumstances. Thus, it would be with naivety and a great deal of dissonance to view the material act of non-compliance with the order in CCT 295/20 in isolation of Mr. Zuma's outlandish statements, which are themselves part and parcel of his contemptuous conduct, because they are the calico that cloth it. The majority judgment finds that it must take cognizance of the unique and scandalous features of this particular contempt. To do so is not to conflate this instance of civil contempt with the crime of scandalizing the court, as the minority judgment implies. The majority is fervently of the view that if we were to ignore those aspects, we would be adjudicating the matter with one eye closed and declining to decide it without fear, as we are constitutionally mandated to do. The majority holds that the cause for concern does not stop there. Mr. Zuma is no ordinary litigant. He is the former President of the Republic of South Africa, who continues to wield significant political influence and in whom lies a great deal of power to incite others to similarly defy court orders. His actions and any consequences or lack thereof are being closely observed by the public. So if his conduct is met with impunity, he will do significant damage to the rule of law. The unique political position that Mr. Zuma enjoys as the former president constitute a further exceptional feature of this matter that justifies a punitive sanction. No person enjoys exclusion or exemption from the sovereignty of the laws of the Republic, and Mr. Zuma is no exception. And indeed, it would be antithetical to the value of accountability if those who once held high office are not bound by the law. In fact, the Constitutional Court has in the past espoused the existence of a heightened obligation on the President by virtue of her or his position to conduct her or himself in a manner that accords with the Constitution, for there are a few office bearers of greater constitutional importance than that of the President. Although Mr. Zuma is no longer President, his conduct flies in the face of the obligation he bore as President. And it is also not insignificant that Mr. Zuma's contemptuous conduct relate to his duty to account for the time that he was in office, so is accordingly inextricably linked to his constitutional obligations as a public office bearer. The Constitutional Court holds that it is disturbing that he, who twice saw allegiance to the Republic, its laws and the Constitution, has sought to ignore, undermine, and in many ways destroy the rule of law altogether. In taking stock of the cumulative effect of these exceptional circumstances, the majority finds that it must grant an order that will vindicate the court's order and protect and maintain public confidence in the legitimacy of the judiciary. Accordingly, the only appropriate sanction is a direct unsuspended order of imprisonment, because the alternative would be to effectively sentence the legitimacy of the judiciary to inevitable decay. In determining the appropriate length of sentence, the majority judgment considered the applicant's proposal of 2 years, the rationale for which is rooted in the sentences prescribed for offences under the Commissions Act and its regulation. Unfortunately, this rationale is inappropriate because the crime for which punishment is being meted out is not a contravention of the Commissions Act, but rather a contravention of a court order, and in turn the crime of contempt of court. Having rejected the applicant's rationale, however, the majority concludes that quantifying Mr. Zuma's egregious conduct to arrive at an appropriate length of sentence is almost impossible task. The question is, what length of punishment is capable of vindicating the authority of South Africa's apex court and the rule of law, while sending a message generally that orders made by a court must be obeyed, and to Mr. Zuma specifically, that his contempt and contumacy is rebukable in the strongest sense. In determining the length of sentence, the majority has considered the unique circumstances of this matter, the nature of the breach, and the extent to which the breach is ongoing. Not only has Mr. Zuma failed to dispute the contempt of court, he has also failed to contest the degree of the contempt. Instead, he has aggravated it. The majority judgment orders an unsuspended sentence of imprisonment for a period of 15 months. This, of course, cannot adequately capture the damage that Mr. Zuma has done to the dignity and integrity of the judicial system. And ultimately, he owes this sentence not only in respect of violating the Constitutional Court, but to the nation he once promised to lead and to the Constitution he once vowed to uphold. The applicant sought costs on a punitive scale. It is tried that punitive costs are exceptional and are reserved for instances where a litigant has conducted themselves in a clear and indubitably vexatious and reprehensible manner deserving of extreme opprobrium. The applicant submitted that punitive costs are warranted because Mr. Zuma's conduct smacks of malice and his public accusations are utterly bereft of supporting facts. These submissions are persuasive. This case does not merely concern an apathetic respondent. It concerns a respondent who breached an order of the Constitutional Court, chose not to explain why, and elected instead to make provocative, unmeritorious, and vituperative statements that constituted a calculated effort to impugn the integrity of the judiciary. When Mr. Zuma's contempt is considered alongside his derisive statements and disdainful attitude, it is without question that punitive costs are warranted. In addition, the majority laments the rise in a casual and reckless attitude adopted by many litigants who see it fit to level unsubstantiated accusations against the judiciary. This cannot be tolerated or encouraged. It is simply not permissible for a disgruntled litigant to dismiss the reputation of the judiciary or its members without fear or consequence. This is not the status quo in our constitutional democracy and constitutes a pattern to be lambasted, especially when it is exhibited by an influential figure like Mr. Zuma. Mr. Zuma's conduct has undoubtedly set an example to the public. So let this court order follow suit. Let it be known that she or he who abandons all ethical standards in pursuit of a cause does so at their peril and must prepare to meet the award of punitive cost that naturally follows. The majority judgment concludes thus: the right and privilege of access to an effective judicial process is foundational to the stability of society. Indeed, courts are the pillars of a democracy and the keepers of its constitution. No person is above the law, and every person, whatever be her or his rank or condition, is subject to the ordinary realm of the law and amenable to the jurisdiction of its tribunals. An act of defiance in respect of a direct judicial order has the potential to precipitate a constitutional crisis. If with impunity, litigants are allowed to decide which orders they wish to obey and which they wish to ignore, then our Constitution is not worth the paper upon which it is written. I too cherish the ideal of a democratic and free society in which all persons are as equal in opportunity before the law as they are in accountability before it. So my duty as I hand down this judgment is clothed in the duty I owe to our Constitution and to the rule of law that undergirds it. I am left with no option but to commit Mr. Zuma to imprisonment with the hope that doing so sends an unequivocal message. In this, our constitutional dispensation, the rule of law and the administration of justice prevails. The minority judgment, penned by Theron J. and concurred in by Jafta J., agrees that Mr. Zuma is in contempt of the order made in CCT 295/20, but concludes that it would be unconstitutional to grant an order of unsuspended committal in the context of motion proceedings if the committal is not aimed at coercing compliance with a court order. The minority's judgment agrees wholeheartedly that this court must defend its orders and authority, but stresses that it can only do so within the bounds of the Constitution. It warns that while satisfying an undesirable desire to address Mr. Zuma's scandalous disrespect for this court, an order of unsuspended committal would trample over the constitutional rights of alleged contemners, including Mr. Zuma. After surveying our jurisprudence on civil contempt, the minority judgment concludes the following. First, that civil contempt has dual remedial and punitive processes, with the main process of civil contempt proceedings being the enforcement of the court order, and that it had found no case in the history of our jurisprudence in which a punitive committal order had been ordered. Secondly, that the Constitutional Court had yet to consider the constitutionality of punitive committal orders in the context of civil contempt proceedings, but has concluded in respect of criminal contempt of scandalizing the court that a summary contempt procedure intended purely for penal purposes is inconsistent with the fundamental rights protected by Section 12 and 35, subsection 3 of the Constitution, because there is no interference in the judicial process or the administration of justice, which calls for swift remedial action. The minority judgments note that it is not enough to say, as the majority judgment does, that the contemner allows punitive committal to be ordered in civil contempt proceedings. The Constitution is the supreme law of this country, and the common law is only instructive to the extent that it is constitutional. The minority judgment has therefore considered whether a common law rule allowing a civil court to order a punitive sanction of committal with no pet remedial purpose constitute a justifiable limitation of the right to freedom and security of the person and an accused's rights to a fair trial. The minority judgment concludes that depriving a contemner of liberty without a criminal trial limits Section 12 of the Constitution. While acknowledging that an alleged contemner in the context of civil contempt proceedings is not an accused person for the purposes of Section 35, subsection 3, it concludes that Section 35, subsection 3 remains relevant because had the contempt been adjudicated in criminal proceedings, the alleged contemner would have enjoyed the protections of Section 35, subsection 3. In this regard, the minority judgment identifies a host of respects in which civil contempt procedure falls short of the protections enshrined in Section 35, subsection 3. First, although civil contempt proceedings are a hybrid of civil and criminal elements and therefore must be conducted in a manner which is grounded in Section 12 and Section 35(3) of the Constitution, the adaptation of motion proceedings to reflect the hybrid status depends on a judicial officer's assessment of what seems fair in the circumstances. By contrast, the procedural rights in Section 35, subsection 3 are peremptory. Secondly, civil contempt proceedings, especially when brought on an urgent basis, as in this case, limit the right to have adequate time to prepare a defense as enshrined in Section 35, subsection 3b. Thirdly, the consequence of granting direct access in this matter is that the majority judgment's committal order is unappealable, which limits Section 35(3)(0) of the Constitution. Fourthly, the motion procedure limits the alleged contemner's fundamental right to remain silent and to be presumed innocent to the extent that it requires the alleged contemner to present a defense before the initiating party has made out a prima facie case against her or him. The minority judgment concludes that these deficiencies amounted to serious violation of constitutional rights when one has regard to the fact that Section 12 and Section 35, subsection 3 protect a profound and essential right to freedom, which is the bedrock of our constitutional order. It concludes that in an open and democratic society based on human dignity, equality, and freedom, litigants are not prosecuted criminally in civil court by their adversaries in circumstances where they are not afforded an opportunity to cure their contempt in order to avoid being deprived of their liberty. Although a contemner faces a deprivation of liberty without a criminal trial, when the committal order sought is coercive, as well as when it is punitive and unsuspended, the minority judgment explains that the limitation of rights inherent in civil contempt procedure becomes unreasonable and justifiable and unjustifiable when punitive committal is ordered for two reasons. The first is that while civil contempt proceedings serve the legitimate purpose of providing successful litigants with a speedy and effective means of enforcing court orders, when the relief sought is singularly punitive and not linked to enforcement, this justification for limiting rights falls away. The second is that the limitation of rights is substantially tempered when the contemptor can avoid imprisonment by complying with the court order. The minority judgment holds further that granting punitive court orders against contemptors also serve the important constitutional purpose of defending judicial authority and upholding the rule of law. But it notes that the rule of law is undermined when judicial authority is protected at all costs. It warns that in this case, when determining the weight that should be accorded to the rule of law and enhancing functions served by the limitations identified above, one must assess the threat to the rule of law posed by Mr. Zuma's civil contempt and not his inflammatory statements. This is because, as the Commission and the Helen Suzman Foundation accept, Mr. Zuma's remarks arguably amount to the crime of scandalizing the court, which is a separate species of contempt. Neither the Commission nor the Helen Suzman Foundation has asked this court to punish Mr. Zuma for this separate contempt, and it is inappropriate to bolster the justification for granting the relief in motion proceedings involving civil contempt by pointing to the threat posed to the Commission of a separate offense altogether. In any event, the minority judgment emphasizes that constitutionality is determined objectively, and it would be a mistake to fixate on Mr. Zuma's conduct in particular. For these reasons, the minority judgment concluded that it is unconstitutional to grant a punitive committal order with no paid remedial relief in the context of civil contempt proceedings. The minority judgment laments the invidious position the Constitutional Court has been placed in by the Commission. Although the Commission sought Mr. Zuma's attendance in 2018 already, it only drew the Constitutional Court into the arena by launching an urgent application in late December 2020. Instead of pressing criminal charges against Mr. Zuma for contempt of court of the Commissions Act, which it had previously threatened to do, it compelled the Constitutional Court to solve a problem born of the Commission's overly different approach to Mr. Zuma. Though the substratum of its dispute with Mr. Zuma was non-compliance with the Commissions Act, the Commission has effectively sought to transform that dispute into one between Mr. Zuma and the Constitutional Court. The minority judgments mentioned all of this to demonstrate that the choice between holding Mr. Zuma accountable and protecting his constitutional rights is a false choice. It is open to the Commission to refer Mr. Zuma's contempt of this court's order and the Commissions Act to the Director of Public Prosecutions. The minority agreement agrees that Mr. Zuma's contempt exposes him to an order of committal, but concludes that the constitutionally compliant approach would be either to make an order of coercive committal aimed at inducing Mr. Zuma to comply with this court's order if the Commission's term has not come to an end by the time judgment was handed down, or an order referring the matter to the Director of Public Prosecution for a decision on whether to prosecute Mr. Zuma for contempt of court. In the final analysis, the Constitutional Court makes the following order. 1, the application for direct access is granted. 2, The Helen Suzman Foundation is admitted as Amicus Curiae. 3, it is declared that Mr. Jacob Zuma is guilty of the crime of contempt of court for failure to comply with the order made by this court in Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, versus Jacob Zuma. Mr. Jacob 4, Mr. Jacob Zuma is sentenced to undergo 15 months imprisonment. 5, Mr. Jacob Zuma is ordered to submit himself to the South African Police at Nkandla Police Station or Johannesburg Central Police Station within 5 calendar days from the date of this order for the station commander or other officer in charge of that police station to ensure that he is immediately delivered to a correctional center to commence serving the sentence imposed in paragraph 4. 6, in the event that Mr. Jacob Zuma does not submit himself to the South African Police Service as required by paragraph 5, the Minister of Police and the National Commissioner of the South African Police Service must, within 3 calendar days of the expiry of the period stipulated in paragraph 5, take all steps that are necessary and permissible in law to ensure that Mr. Jacob Zuma is delivered to a correctional center in order to commence serving the sentence imposed in paragraph 4. Mr. Jacob Zuma is ordered to pay the cost of the Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, including the cost of 2 counsel on an attorney and client scale. I hand down the judgment.
As the court pleases.
The court will adjourn.
Yeah. This one is it. How long can you laugh?